The meeting of the Zoning Board of Appeals will now come to order. Roll call.
Mr. Bacilli? We're waiting for the cable TV to,
He's on.
not on mine, okay, yes. Mr. Camerata? Yes. Mr. Corrin? Yes. Mr. D'Angelo? Yes. Mr. Tucker?
Yes.
Yes, and Mr. Colometto is absent. Quorum is present. First matter before the board is application A1214. This matter has been continued from the meetings of September 26th and October 31, 2012. This is the application of Kim Falzone, trustee of 1 Lawrence Road Realty Trust, 9111 Avolo Oaks, Wilmington, Massachusetts, requesting minimum lot size and frontage and all setback dimensional regulations to enable the appellant to have the structure located on Lot 13 at 1 Bay Road, Revere, Mass., fully and completely conform to all said regulations.
Good evening, Mr. Chairman, members of the Zoning Board of Appeals. My name is Attorney Lawrence Simeone, and I represent Kim Falzone, trustee of 1 Lawrence Road Realty Trust. This evening, she seeks a variance in accordance with Mass General Laws 40, Section 10, requesting all dimensional requirements in order to legalize an illegal structure that presently exists on the property. The only thing that protects this structure is the statute of limitations having expired 6 years from a building permit having been issued on April 11, 2000. The property is Lot 13, Bay Road, as identified in the assessor's map. It's 1,800 square feet, and it's in a two-family district. The property currently is a 3-bay garage, which was constructed with a building permit number 6543. It was issued by Building Inspector Lance Kelly on April 11, 2000. The building permit clearly establishes a finished inspection as of April 20th, 2000 by Inspector Richard Dix. Since that time, there's been no exterior improvements, nor is there any exterior proposed improvements in this application. The building, as you see it, was the building that was built and signed off on April 20th, 2000. The garage is an accessory structure, and a special permit was issued by the Zoning Board of Appeals back in 2000, either January or 1999, late 1999. The tortured history of this building is the fact that during the special permit application process, my client, who had bid on the former Martinetti property, which was a junkyard on lot number 13, indicated on the application, accidentally and incorrectly, that he was the owner of both 7 Lawrence Road, at that time he was the owner, and number 1 Lawrence Road, which is lot 13. Subsequently, the building inspector made a determination that a special permit would be needed in accordance with 1740-040, alterations of 1 and 2 family homes. Again, 7 Lawrence Road was a single family home. And if that were the case, if he had owned both, then there would be a legal structure there. But it isn't. After the special permit was granted, the building was constructed, this being the 3-car garage. Since that time, Mr. Coco sold 7 Lawrence Road, leaving the 1 Lawrence Road with 3-bay garage standing by itself. A 3-bay garage in a residential district is an illegal use, can never be converted to a legal use. However, it is always good under the law if you can convert something from an illegal status to a legal status. The law and the courts have favored such an action. The former accessory structure was never legal. At its inception, unfortunately, the special permit was defective because, as I've stated, lot 1, unit number 1, address number 1 Lawrence Road, and number 7 were not in the same name, and therefore the property could not merge. It is not a non-conforming structure as defined under 1708-580 in our ordinance. The Site Plan Review Committee on April 10th, 2012, my client went without me. He met with the site plan review and they got this pre-screening letter. In this pre-screening letter, they recommend that Ms. Falzone gets a special permit from this honorable body in accordance with 1740-040. Because the building inspector has not made any determinations, it's clear that the 3-bay garage is not a non-conforming structure. And the building inspector, it is alluded to in this letter that the building inspector has made a determination that this is a non-conforming structure, although he's not signature on the letter, and he's not even a member of the site plan review. He's an ad hoc member of the committee. It says that he made a determination that it's a non-conforming structure, and he made a further determination that the actions and proposals under the application exceeded the non-conforming nature of the structure requiring a special permit. The letter is simply wrong. It's plain on the facts. It's wrong on the facts and wrong on the law. The structure was not created lawfully. It is not a non-conforming structure. It is protected, as I said, by the 6-year statute of limitations. It is an illegal structure protected by that statute. The applicant, Ms. Falzoni, does not wish to alter the structure in any way since the time it was created, and therefore it's not an alteration that requires a special permit. It needs a variance. Only under a variance can this board take an illegal structure and make it comply and become legal. So as to the request for all the dimensional requirements to the structure, I respectfully request that the board grant those. This leaves us to the issue of whether, in fact, the board can grant an undersized lot. I've talked to the clerk. The clerk believes that you don't have authority under the Mitchell case to grant an undersized lot. So I haven't had an opportunity to read the Mitchell case. But I know that this particular property years back was a developed parcel. It wasn't a vacant parcel. There's a history to the parcel. I haven't had an opportunity to verify it, but there was structures on this parcel historically, so therefore it wasn't vacant. If it's not vacant, it doesn't meet the test under the Mitchell requirement because Mitchell had a vacant lot that was less than the appropriate size. So if my client, Mr. Coco, told the building inspector in 2000 that he had not merged the lots, that he had put them in two different names, there's no doubt in my mind Lance Kelly would have told them, then you need a variance for the lot and you need a variance to build that structure. No doubt in my mind. But Mr. Kelly was not aware that the lots were in separate ownership, and that's why we're here today. It's up to the board if they want to put this torturous history behind. All we can do is ask you to do it. We've cited the history. There's no evidence of fraud or illegality or something that Mr. Coco could have done. Just the opposite. In 2000, when he did this, people couldn't wait for him to do it. I have Mr. DeLegro here. He was there at the time. Mr. DeLegro will tell you that they couldn't, the city fathers and administrators were doing everything they could to get rid of those Mantini properties. They were scattered about the city, and they were a blight. My client bid on it, for good or for bad. He made this error, and he's lived with the problem ever since. Had he properly been represented, then it may be a different result. That's an advertisement. If you have any questions, Mr. Chairman, I'm glad to answer them. And Mr. Cosmo DeLegro is here. Should you want to take a statement from him, he'll tell you just what happened at the time.
And who is that?
I think Mr. DeLegro will tell you that the property was a blight to the community and that they were cooperating and helping him, Mr. Coco, buy that property and develop that property so that the neighbors would be relieved of a blighted parcel of land.
I don't think anyone would be in disagreement of that, Council.
Okay.
It's
Well,
it's
it would be-
an act that having it a single-family home go in there was the issue, not that the property was blighted before the
Well, I'll tell you.
applicant or owner bought it.
I'll tell you that the issue for Mr. Coco is that it was built that way. As you see it, that's how it was built. Mr. DeLegro was a member of the building department's office. They signed off on that structure. There's been no alterations, exterior
Are you
alterations.
telling me that the gentleman who works for the building department's going to come up here and say a single-family home was built up there when this was signed? He's going to say that under the pain and penalty of perjury? There was no structure up there when they signed this. I had spoken to the gentleman who signed the final. It was for a garage. There was no single-family home
There was
upstairs.
there's no exterior changes.
But there was no habitat upstairs.
Again, I can't attest to that.
But that's what you're here for, to make this that's why you're here, because of the single-family home being put there.
No, I'm here to legalize that structure, Mr. Chairman, which will entitle it to be a two-family home. But he wants a one.
It wouldn't entitle you because you don't have the dimensional requirements for parking for a two-family home there, do
He's
you?
got 4 parking spaces.
There's 3.
There's 4. He's got space for 1 on the left-hand side of the building. But he's asking for 1.
Okay.
Thank you.
There anybody who wishes to speak in favor? Please step up to the microphone, state your name and address for the record. Good evening, Mayor.
Good evening. My name is Daniel Rizzo, 35 Rowan Road, Revere, Massachusetts. Mr. Chairman, members of the board, as you know, I very, very rarely come up here as a proponent or opponent. I look at our boards, my appointed boards, as autonomous and capable of making your own decisions. So really, it's only in those rare occasions that I feel obligated to come before you and in this case, speak as a proponent for this particular variance. First of all, I have known Mr. Coco for a great number of years now, probably close to 25 years. And probably over the last 10 or 12 years, I've had conversations with him over this property. I understand that from the very, very beginning, it has not been a smooth process to get where we are to today. And even as of today, there's some talk about maybe it should not be in the form of a variance, maybe it should be a special permit. The bottom line is, this is one of our residents that has been basically living a tormented life over the last 12 years with a combination of cease and desist slapped on his door, building inspectors showing up from time to time, all the while that he was promised by 2 administrations ago that what he has done was in fact going to be legal. You know, should he have had something in writing, or should something have been done at that time to make sure that he didn't find himself in this position 12 years later? Of course. At this point, I'm just looking on behalf of the applicant to bring some finality to this. I mean, obviously, he has to live up to all the expectations of the plumbing inspector and the chief fire inspector and plumbing and so on and so forth.
Mayor,
But-
just for the record, it's not he, it's a she, it's a trust.
She.
So
That's
that's the whole thing that confused this from day one.
Okay.
We have to deal with the owner of the property, and that's a Karen, and it's a trust.
Okay.
Karen Falzone Trust. Trustee.
Okay. Well,
Kim, I'm sorry.
Mr. Chairman, my apologies, Kim. But, I mean, I do know that this was all initiated back at that time. I guess as an interested party, he was, I guess, kind of a party to this in some fashion, whether on a consultant basis or otherwise. The bottom line is, I believe that where this property really has been a source, one of the things to me when I think about granting a variance is you talk about a hardship. I don't think anybody has had as much of a hardship as this applicant has had for as long as they've had, at least in my mind. So, life isn't perfect, and I wish this could have been a perfect scenario that was just a layup for everybody to consider it as such. But in this particular case, given the extenuating set of circumstances, given the fact that, and I know it doesn't play into the application, but the reality of it is that they did clean up a piece of property that the city wanted cleaned up. I don't believe at this point it should continue to be a headache for them. And so it is my hope that after looking at all the facts and looking at everything that's occurred and trying, I always try, quite honestly, to put myself in somebody else's shoes whenever I look at any kind of vote. And, to have this hanging over your back or hanging over your head for 12 years, that to me is an extraordinary burden. And I am hopeful that after looking at all the facts, you'll grant the variance and legitimize what has gone on down there. And quite honestly, I'm not sure if there's any opponents here or have been any opponents in the past. But also, I mean, I recognize that that plays into any type of application that exceeds what could otherwise be done by right. You know, if you have a large amount of people in opposition, you say to yourself, well, this is a detriment to the neighborhood. But to my knowledge, at least from where I sit and from what I've been told and what I've heard, there's not, I'm not aware of any opponents. Maybe there are, but I'm just, what I've heard and seen so far have been none. So I'm asking the board to strongly consider approving this variance. Thank you very much, Mr. Chairman.
Thank you. Anyone else, Counselor? For the record, I believe there were no opponents listed in our last hearing. Am I correct, John? There are none. Go ahead,
Mr.
John.
Chairman,
Thank
members
you
of
for
the board, John Powers, 46 Neponset Street, this city. This is a situation that's been in existence for quite some time. I was not on the city council when this project started or was completed. My understanding is that it's a three-car garage and there is an apartment upstairs, and judging from the size of it, I'd have to assume it's a one-bedroom apartment. I've spoken with the neighbors down there, particularly the abutters, and they really have no objection to this. As Mayor Rizzo previously stated, that was a blighted area. I remember it clearly because a friend of mine, Sergeant Al Beer from the police department, lived next door, and I think he was somewhat annoyed with it the way it was. Subsequently, Mr. Coco cleaned it up. I believe his daughter has the property now. It's a one-bedroom apartment. My only concern is that it remains a one-bedroom apartment, that the downstairs is used for parking and/or storage. I just don't want to see any more two-bedroom apartments, three-bedroom apartments built in the city when we can, in fact, restrict them because of the, as you all know, if you watch the local cable channel, you'll see that the superintendent of schools is up here all the time talking about building new schools. And even after the McKinley School, my understanding is they're going to be looking for another school. And that's certainly a burden that I know none of us in the city, yourselves or any of us in elective office, want to see placed upon the ratepayers in this city. Construction of new schools. So I'm not opposed to this. I support it. I think the gentleman has cleaned up the property considerably. My only concern is that it remain a one-family home with a three-car garage underneath it, even though he doesn't need that third bay for parking under the zoning. But it can be used for storage or something like that. I just want to make sure it remains the way it is now. Thank you.
Thank you. Are there any other proponents? Kindly step up to the microphone, state your name and address for the record, please.
Cosmo DeLegro, 20 Case Drive, Revere. At the time, I was the assistant building inspector. And before when all this was happening, Mantini owned this place. It really was a real blight place. And we went to court a few times over the years, and nothing was ever done. And then I believe when Bob Hass took over and we got a lawyer, Denise DiCarlo. She took it over, and I went to court with her, and we finally got something done, and we were able to get rid of the blight area. And the people around there complained all the time about this. Then finally, when Mr. Coco had come over and he'd done some of his work there and what he'd done, and it cleaned up the place, and that made everybody happy. And that's all, as far as I was concerned, it was okay with me. I just want to tell you I'm in favor of it. All right, thank you.
Any other proponents? Please step up to the microphone, state your name and address for the record.
My name is Linda Torregrosa. I've known Joey and Kim for forever. During the building of that building, I was there when it was in construction, and The building department was there several times while I was there, and while the apartment was being built, so they had knowledge of it, and they didn't put a stop on it. And he had, I assumed, all of the right things to build it.
Thank you. Are there any other proponents?
My name's Mike Lawyer. I live at 570 Revere Street. My kitchen window and bedroom windows face that lot. And, I've been there 30 years. And what he did was an improvement to the property and to the property value of the neighbors. That was a lot that everybody used in the city of Revere to dump stuff there. It was a blight on the neighborhood. And, he did a nice job there, putting the garages there and, putting an apartment there. It was good for the neighborhood.
So you're in favor of a single-family home being there now?
Well, yeah, he's got an apartment there, right, I
Okay.
mean, I'm not looking to enlarge it or, but he did a heck of a job there, and he should get credit for what he did.
Okay, thank you. Are there any other proponents? Hearing none, I'll close that side of the hearing. Any opponents? Hearing none, I'll close that side of the hearing. Any members wish to speak? All right, before we do a roll call, I would question if we can restrict it to a single-family home on a variance.
You want that as a variance restriction?
Yes, that it's, it'll become a two-family, that it, an 1,800 square foot lot, I mean, single-family home. Yeah, because I mean, it wouldn't conform, it wouldn't be allowed based on the lot size anyways, without coming for a variance for either a single family or two family. Am I correct, Counselor, to state that? I would think you'd agree there.
The grant of a variance doesn't make something non-conforming, because it has to be built at the time, but a hook in a decision that says any further modifications need to be before your honorable body allows the applicant some flexibility if in fact that needs to be done.
Thank you. So you're happy with what I said then?
Yes, I am.
Thank you very much. Okay.
Question now comes on granting the relief requested subject to the restriction that this variance is granted subject to the structure remaining a single-family dwelling, cannot be further altered without the prior approval of the ZBA. Mr. Bacilli? Yes. Mr. Camerata? Yes. Mr. Corrin? Yes. Mr. D'Angelo? Yes. Mr. Tucker?
Yes, with my,
Yes, with the restriction.
yes.
No further business. This is granted, subject to the restriction.
Thank you very much.
No further business, or will be,
The board
closing until-
has agreed to meet on December 12th at 4.
thank you, good night.